how to enforce a CCJ. Tell us what a CCJ is.
Effectively, a CCJ is a county court judgment issued by a county court which shows that the court has agreed a debt is owed.
Right, okay.
And that is literally all it is.
Yeah, and we see a lot of people that go through the court process and obtain a CCJ, but then they come to us looking to get the money.
They do indeed, because 60% of the CCJs obtained in England and Wales, none of them are actually enforced.
Right, okay.
People seem to have this misconception that you've got a judgment and it will say on the judgment that the debtor is ordered to pay. It is not, or very unlikely, that anybody will actually ever pay.
Well, or 60% don't.
Well, 60% don't, which we know.
Yeah. And
the real skill of it is the enforcement. Now, there are various means of enforcement, depending whether it be a business.
This is actually getting the money, enforcing the judgment. Getting the money.
Exactly, but always the thing I would consider first is, just to go back a little bit, is getting the CCJ is relatively easy, but even before that, it's always wise to ensure that the person that you're suing for the outstanding debt has actually got an asset or income against which you can enforce and get the monies. Right,
okay. So, assuming you can win the case, you want to be making sure that you can recover the monies from the individual or business before you take it on.
Absolutely.
And that's kind of what we try and do.
What else we try and do, and in 9 times out of 10 we are correct.
Yeah. Okay. So
you've got your CCJ.
Yeah. Where do you go from there?
You've got your order from the court, and then you can enforce it. Now there are various means of enforcement.
So if we talk about business to business.
Yes, we'll do business to business.
Yeah.
One of the things you can do is what they call a third-party debt order, whereby if you can find out, for example, the debtor's bank account, you can apply to the court for the debt owed to be paid direct to you by that bank, as long as they have a credit balance in the bank.
Yeah.
Equally, it could be in a business is owed money by a customer.
Yeah.
And if you're aware of that customer, which you can quite easily find out, then you can actually apply to the court for that customer to pay the claimant direct, i.e. never actually goes through the debtor. You can actually ask for a warrant of execution, whereby a county court bailiff will go in and basically take a lien, or a charge in other words, over some particular asset, and if they don't pay, then of course the asset could be sold and the money recovered that way. It is however not something we necessarily recommend, because they're not always as effective as certain other means.
There's a difference, isn't there, between a county court bailiff
and a high court sheriff.
Yeah.
A county court bailiff is a civil servant working for the county court. You can, for debts over £600, apply to the High Court for enforcement. Once this writ is issued, then a High Court enforcement officer can start to enforce the debt for you. Now they do have quite wide powers.
Yeah, these guys work differently.
They work differently, and the reason they're more effective, quite simply put, is they are on commission.
Yeah. And these guys can recover goods and assets to the value of the claim.
Goods and assets to the value of the claim. Basically, they can go in, they can seize them, they can hold them, they can sell them, and account to the debtor and to the claimant.
And I think we were saying with all of this, when you go and recover the monies owed, you're entitled to cover the costs of that.
You are entitled to recover the costs, because for any application you make, whether it be for a third-party debt order, a charging order, whatever, there is a fee, normally in the region of about £100.
Yeah.
And that is added to the debt.
Okay, so the court fees are added and the enforcement fees are added. What about things like solicitors fees?
Solicitors fees in the small claims track, there's only a limited amount that can be claimed. Okay. For example, you could be chasing a debt for £3,000, but it might actually cost you £6,000 to have got that. You cannot claim that back from the defendant. There's only a very small proportion that you can actually claim from the defendant.
So you don't get your fees back then?
You don't get no. But you get your court fees back. You get any enforcement fees, but you don't get your legal costs.
Right, okay. So that's third-party debts, and that's bailiffs.
There's also a charging order. It's quite possible that a company owns property, a company could own shares. Once again, you can apply to the court for an order which basically gives you a charge over that particular asset, whether it be property or whether it be shares.
Yeah.
Once again, it can be quite effective.
Uh-huh.
However, the thing about a charging order is that it's really a means of securing the debt. So, for example, you could have a charging order,
Yeah.
have that in place, but then you could also apply for a third-party debt order.
Right, okay. So,
i.e. you can take more than one action at once.
yeah.
There is one other point to consider. If you have obtained a county court judgment, you can actually apply to the court for an order for questioning. And in terms of business, they are ordered to attend court, and they have to provide a whole series of documents to the court to prove their assets and liabilities, income and expenses, and they are required to provide hard copy accounts and whatever. They're also required to give detail to their bank, anything basically about the company. Having got that, you can obviously then use the various means of enforcement, whichever you think is most applicable. Okay.
Now, there's other one for organisations, bankruptcy, or winding up the organisation.
That's always a possibility. You've always got to, if you're going to take that course of action, you have got to be absolutely 100% sure in your mind that if the company is in liquidation or administration, there are enough funds at the end of the day to recover your debt. Now, typically, you'll have to pay a court fee for bankruptcy, and that will always get repaid first above anything else.
Yeah.
However, your actual debt itself, as I say, you've got to be 100% sure that you will recover that debt. And I'll give you an example. We recently sued an estate of a deceased person for a debt of $132,000.
Yeah.
At the end of the day, it did actually take 8 years to do. We only actually got £10,000 out of it. The reason being that once the assets have been realised and the various fees for the insolvency practitioners have been paid, there wasn't actually a lot of money left. So you have got to be, if you're going to go down the bankruptcy route, you've got to make very sure.
So it can be expensive, long-winded.
It can be expensive, long-winded. However, sometimes, if you're lucky, the threat of bankruptcy is it can sometimes be enough to make the debtor pay up.
Yeah.
But it's like anything in this business. If you threaten to do something, you must do it. Do never ever say, I will take you to court unless you pay, for example, and don't take them to court, because they know then that you're probably bluffing.
Yeah. Okay. So we've got a third-party debt order, attachment of earnings, a charging order, or bankruptcy, and we can also bring in people for questioning.
Indeed, but one thing is just to remember, attachment of earnings is really only applicable to individuals who are on PAYE. It's inapplicable against somebody, for example, an individual that's self-employed. The order for questioning can be effective if you don't have full knowledge or have little knowledge about the debtor and their means.
Yeah. Okay. So in terms of getting your money back, let's say getting a CCJ is,
It's relatively simple. It's more of a procedure.
Yeah, but really it's the enforcement.
The enforcement's the key.
That actually gets you the money in most cases.
Yeah.
And you need to kind of have a bit of a plan and idea about how to go about it before you start.
Absolutely, and we have a lot of people coming to us with CCJs that might be 1, maybe 2, 3 years old. Right, they can be enforced, but just remember, after 6 years from a judgment, it can't be enforced without the
Okay, so you can recover CCJs up to 6 years old.
Yeah.
But as we know, the longer you leave it, the worse it gets.
Yeah, absolutely. For example, it could actually be just finding the person.
Yeah.
It could be 4 years. Someone could have moved. They could have actually left the country. We have a case recently where someone has actually left the country. So
finding the person is one thing. If it's individual, but we've found a lot of cases where the company's gone into administration, liquidation, or just no longer exists anymore.
And obviously when that happens, unfortunately, the monies are irrecoverable.
That's right.
By which stage they've all been wound up and everything's moved on, there's nothing left.
Yeah, so these are kind of checks and things you need to be aware of when pursuing.
And it's making sure that people realise that once they get a CCJ, they must act quickly. They mustn't hang around and wait.
Yeah, and it should be part of the process, really, shouldn't it?
It should be, and there should not be a gap or time delay between the judgment and commencing enforcement action.
Brilliant. I think that's enough for today. Thanks, Ed. That's how to enforce the CCJ.
Indeed. Getting better at it.